Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8. The agreement, I think, is a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, I guess, rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one, in January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were seven
There was-
additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. And he understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can't. Oh no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something, and I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000,
Two.
when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds, because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or if it's, I can't tell.
So,
I
but
think
Mr.
I'm
Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is, you're 51 now, 52?
51, ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017, so not that long ago. Given a probation, it was revoked, so you were given an opportunity. Mr. Smith.
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony, 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of
I saw that.
it. He's still not accepting
I
responsibility.
hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over.
I'm so
I let
sorry.
you talk, so
I'm
don't talk
sorry.
over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence to be sent.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement, because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the
I'll print the exhibits out.
right here, right here.
They don't X them out because it's set for sentencing, so I can still print out the stuff from next week. Well, once it's taken care of, they remove this.
Good grief, I just wrote 2023. 2028? Great. At least I'm making us younger, not older. What is this? Hers.
I'm gonna take care of it, Mr. Mayor.
All right, ma'am, good morning. Are you Melissa Taylor? Yes, ma'am. And will your client waive the formal reading of the indictment in each case?
So wait,
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Capon did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Capon that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail and again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's been none that I've observed that would lead me to think that she's currently mentally incompetent.
All right, and Mr. Nichols?
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with the second-degree felony offense of assault on a peace officer from October 2nd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct, yes.
All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024, and how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you did what they've charged you with?
yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes,
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them
I've made a
concurrently.
recommendation for 12 months on that
Okay,
case,
12.
Your Honor, and the defense had made a recommendation for probation concurrent with the 1 day.
Okay, so in essence, a cap of 12 months then? Would
Yes,
that,
Your Honor, that's fair to say.
It concurrent.
with everyone's permission,
Yes,
can I
sir.
make that?
So you're 12 months and 5 years.
well, that's fine.
Let's see.
But
Cap. So it would be a cap of 12 months on that state jail case. Do you understand?
Yes, ma'am, and that's for the
One
warrant.
of the buildings.
No, it's
No, it's for a credit
I'm sorry,
card.
credit card.
So what that means is that if we go forward this way, you're leaving your punishment up to me.
Okay.
And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit debit card abuse case, then you're waiving your right to appeal. I can give you 5 years, I can give you less. It'll all be determined when I get the information at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. All
Your Honor,
right?
I do have a support letter that I tendered the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. That's exactly when both of y'all do better. When she does it, I think of that all the time. All right, sir, you said Dog Wilson? Ma'am, I'm sorry. I was looking at the, down this way and not at you.
Sidell Wilson?
Sidell?
Yes, ma'am.
Okay. And
Yes, Your
Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Let's see. I'm getting there. All right, Ms. Wilson, in cause number 22-40450, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. And is that true or not true?
Yes, Your Honor.
Is it true? Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Yes, Your Honor.
Judge, since we have an agreement.
Listen, hold on.
I'm sorry.
Thank you.
Since we have an agreement, we could drop 3, 4, 5, and 6, and just go to 7, if that's all right with the court.
Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true?
True.
Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true?
True.
And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily?
True.
Were they volunteer?
Volunteer.
And did you, it's okay.
Yes, Your Honor.
It's all right.
right.
You're good.
Thank you.
Did you enter those pleas of true freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Ms. Wilson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a habitation, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, Your Honor.
Good luck to you, ma'am.
Thank you.
Okay. Good morning. Are you Stephanie Moore? And Ms. Moore is on probation for robbery. There's a motion to revoke, and what's the,
Judge, Miss Moore's been absconded for 7 years, and she's not been picked up. I almost just don't really know how to proceed because we have no idea what's been going on with her for 7 years. I'd like her to have an opportunity, if she chooses to tell the court what she's been doing before we really make a recommendation here. And obviously, she can choose not to, but
Mr. Rojas?
Judge, I spoke with Ms. Moore. She's told me what has been going on for the last 7 years. I mean, she would like to tell the court where she's been, how her life's been going on. So, Ms. Moore?
I've been in a bad domestic relationship and was not allowed to pretty much do anything. Put up a mailbox, go get any kind of medical help, get an ID. When I just got strong enough to leave that relationship, I put up a mailbox, got some health insurance, and realized that I needed to get my driver's license back and be, I have to take care of my past, and this was my past, and he wouldn't let me do that. I asked him over and over again to help me, support me behind this, or come at least drop me off at the jail so I could take care of this, and he, just the way we lived and the way he lived, it just wasn't something that was able to do. When I did try to leave, he killed my cats and pulled me back to the house. I broke my wrist. He broke my wrist this last time, and I just fled to the cops and screamed out of the neighborhood. And the cops came, and I ran to him and just said I need help. And so I knew this was here, and I knew that I had to take care of whatever I needed to do to put this behind me, so that I want to live a normal life and have my license and go get a job and have a home and a mortgage and land. And I'm 48 years old, about to be 48 years old, and I just want to get my life back without that.
So, I mean,
she was ordered to safety back in 2018 and did not report.
No, I went to safety. I've done safety.
In 2018?
Then comes the moment that changes the entire courtroom. Judge West acknowledges that Wadsworth appears sincere, but she makes it clear that sincerity alone cannot erase years of criminal history. She points to his age and the many opportunities he had already received, including previous probation. Then the judge delivers the statement that immediately stands out. She says she honestly believes he has one of the worst criminal histories she has seen. The numbers are staggering. The hearing references 19 misdemeanor convictions, additional misdemeanor cases, 21 felony convictions, another pending case, and even more cases that had been dismissed through plea agreements. The defense argues that many of the older offenses came from the same period and emphasizes that Wadsworth had stayed out of trouble more recently. But the judge points to later offenses as evidence that the pattern had not simply disappeared. Ultimately, Judge West accepts the guilty plea and sentences Wadsworth to 8 years in the Texas Department of Corrections, with credit for qualifying time already spent in custody. She also explains the consequences of the judgment, including his legal ineligibility to possess firearms or ammunition under Texas law. This hearing shows why a plea agreement is only part of the story. The defendant's history can completely change how the court views the case.
If you want to do that, talk to her about
Can I
it.
sometimes talk to her?
Yeah, y'all visit, and then we can just go through the motion, get the pleas of true or not true, let probation do a more detailed visit and figure out what's been going on and where, and maybe confirm some of those things, and then we can see what our options are when we come back for sentencing. It's the only thing I know to do.
I agree, Judge. It's
Okay.
Such a unique situation, and
All right.
I'd like to hear from probation.
Sure, okay. So to visit with her, if y'all want to do that, we can go through the motion today, and then we'll see where we are. All right, are you Laddie Johnson?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Johnson, in cause number 24 DCCR 2388, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor resisting arrest, and that is from October 24th of 2024. And how do you plead to that charge?
This courtroom hearing takes a dramatic turn when Judge West begins reviewing Matthew Wadsworth's criminal history. Wadsworth had already pleaded guilty to aggravated assault with a deadly weapon, with a plea agreement that placed an 8-year cap on his prison sentence. But once the judge reviewed the pre-sentence report, the seriousness of his past became impossible to ignore. The prosecution pointed out that his record included numerous felony convictions stretching back years, with additional offenses appearing again later in his life. Wadsworth's attorney argued that medication and substance abuse issues had played a major role in his repeated problems, and Wadsworth himself asked the court for another chance. He explained that when he stays on his medication, he believes he can function normally and stay out of trouble. He described himself as a father, grandfather, and electrician, and told the judge he wanted help breaking the cycle. But Judge West faced a difficult question. After so many previous opportunities, could she trust that this time would really be different? And that question becomes even more serious when the judge begins counting just how extensive his criminal record actually is.